And
Sure,
when he has joined, he will be able to provide his comments.
sure, sir. Hello, everyone. Thank you for joining us today for the last session for today, which is on investment treaty arbitration. I thank the panelists and the speakers for being here today. We have with us today Mr. Rajput, who is a member of UN International Law Commission, and he was the chairperson of the drafting committee for the 69th session of the ILC in 2017. His areas of expertise are international law, dispute resolution, international investment law, and international trade law. We thank him for being here. We also have with us Mr. Kasi Bhatla. Uh, he is presently serving as the Deputy Legal Advisor for the Ministry of Law and Justice, Government of India. Before that, he's practiced as an advocate for many years. We thank you, sir, for being here as well. We also have with us Mr. Nair. He's the founding partner at Arista Chambers, which is a dispute resolution, and he's known as a dispute resolution specialist with extensive expertise in many fields, including public law, commercial litigation, and arbitration. Um, it's great that Mr. Don is back with us. He'll be moderating the session for today. I call upon him to take forward the session now.
Hello, Isha. Thank you. Can you all hear me?
Yes, sir, we can hear you.
Okay, my apologies. I'm actually using my phone instead of my computer for some reason. So in any event, I'm sorry for the delay and sorry for the issues to date. Thank you very much, Professor Garg, for inviting me to be involved with this very important session. ISDS in investment arbitration, international investment arbitration, is a very timely and very important issue. I probably should have let Isha continue throughout. She was doing such an effective job. So thank you, Isha, for that. For many of you who are, I think, new to the area, let me give a couple sort of minutes of setting the stage, perhaps, before I go to the three very distinguished and knowledgeable presenters from India that have actually a lot of experience in the matter generally and in the particular topics that they're going to be speaking about. In international investment arbitration is a product of essentially the last 70 years. I mean, I suppose there have been protections under international law that go back hundreds and hundreds of years, but this system of treaties developed beginning in the 1950s. We now have a system of close to 3,000 bilateral investment treaties and also free trade agreements that have investment chapters that provide various sorts of protections. And what has developed under that is a mechanism to allow the investors to have direct remedies, a direct right of access to resolve disputes as agreed to in the bilateral investment treaties. Now, remember that the development of the International Investment Treaty and the protections to investors emerged because it was felt that international law was inadequate because it gave the two states the ability to protect or not protect the investor, and the recourse was really diplomatic protections as opposed to any sort of, I'm going to say, legal proceeding that was involved. What we have under international investment arbitration are typically four standards that are applied, and that you'll find in most, although in different formulations, but in most of the international investment treaties. And these will include a national treatment. We treat your state's nationals the same as we'll treat our state's nationals. MFN, or most favored nation, which is if you give a better deal to another state and their investors, our investors will automatically get the benefit of those provisions as well, those additional protections. Perhaps the most controversial is the third one, which is fair and equitable treatment. That includes full protection and security. And it's a wonderful term, fair and equitable treatment. We can all agree that we should always operate fairly and equitably. But what does that mean? And how should arbitrators, but how should states and how should the other parties to an investment dispute view those types of provisions? The fourth one that you'll typically see is expropriation with prompt compensation. And so that's in some ways the international investment arbitration framework that we're now going to be looking at what the current issues are, the hot issues in international investment arbitration. I must say that there is a lot being written. There is a lot of activity going on at UNCITRAL, the United Nations Commission on International Trade Law, that has one of its working groups, Working Group 3, that has been convened to really delve into and see if there are harmonization, unification efforts that are appropriate in this area. I think that the last point that I'll make before going to the speakers is to note that that the issue is not simply a developing country issue. It is also a developed country issue. And the matter that springs most to mind involves the decision of Germany about close to 8 years ago now, I suppose, after the Fukushima nuclear accident in Japan. It decided that it would no longer employ nuclear power as part of its governmental strategy and approach in Germany. And that was great, wonderful sort of concept and idea, just one big problem, and that is that there were several nuclear reactors in Germany that were multi-billion-dollar facilities that had many, many, many years of operations left, meaning 20 and 30 and 40 years of operations. And there was a huge revenue stream that was expected to come off of that now was put not just in doubt, was actually sort of destroyed by government action. The only problem was that these were owned by Swedish investors, a big Swedish company. And when the Germans became aware that the Swedish company was not just going to proceed under the national courts of Germany that are well regarded for the careful, fair work that they do, but we're also going to proceed through their bilateral investment treaties, there was outrage and horror. And Germany actually has been, very, very strong and at the forefront of the efforts then of the European Union to bring, I suppose, change, clarity, protect the interest of states, and we'll see that throughout the presentation. I think with that, what I'd like to do is we've got sort of three very, very interesting issues that are involved. And I'd like to turn it over first to, excuse me, just one second here. Turn it over first to our topic on, excuse me, to our topic on potential investor-state dispute settlement issues that are arising post-COVID. There are lots and lots of issues. And to present this is going to be Dr. Anuruddha Rajput. He is a member of the United Nations International Law Commission. He served as the chairperson in its drafting session in 2017. He's had many wide-ranging interests, including evidence before international courts and tribunals for long-term programmatic work. His areas of interest are general international law, law of evidence and procedure in international adjudication, law of the sea, international trade and investment disputes. He's been a practitioner in residence in Berlin, Germany. He's practiced before the Supreme Court of India and currently acts as a consultant in public international law and international arbitration with Withers LLP. I'll introduce each speaker serially. So we'll start with Dr. Rajput. What we've agreed is that each of the speakers will spend 15 to 20 minutes on their topic. We'll take them all, then three, we'll roll them one after another. We will save time at the end for questions from the attendees. So keep your pens out, be attentive, and come up with great questions. And with that, let me turn it over to Dr. Rajput.
Hello, I hope I can be heard at least because I'm having serious troubles with network. Can I be heard at least? Because I'm now logged on a phone and...
Yes, sir, you're audible.
Okay.
Sir, I think you're on mute, as we're not able to hear you now.
Hello, hello.
Yes, sir. That's good.
Okay. Hello. Still no?
Yes, sir, we can hear you.
Okay, good. Thank you very much.
Yeah.
I think you're still muted.
Loud and clear. Yeah, we can see you fine.
Okay, good. Okay. I think I'm stuck on my screen now again. Or I propose we go through the webinar and I try to come back in the end because let's see if it is working or not, because I can't, my system is frozen at the moment. Can I be heard at least?
Yes, sir, you can be heard though.
Okay. So you want me to proceed?
I think Mr. Don can help in that regard, what he proposes.
Yes. Yeah, that's what I meant. Sorry. Yeah. Okay, let me start and then we see how it goes. Firstly, thanks to the organizers, in particular to Dr. Risham Garg, Professor Risham Garg, for this very kind invitation. A very dynamic academic with a strong sense of practice. To him, I've always remained grateful and would remain because he helps me in finding the most talented Indian students who could work with me on international law issues. What I intend to do today is I would be speaking about investment treaty arbitration post-COVID. Now, a very basic understanding of investment treaty arbitration is that investment treaty arbitration is a mechanism for investors to challenge governmental measures. Now, the exceptional nature of the regime is that it allows investors to challenge sovereign measures. And that is something distinct from other areas of international adjudication because they mostly don't recognize the rights of individuals or even where they recognize, they don't allow in any manner to challenge exercise of sovereign rights except in the regime of human rights. Now, because investors have this right to challenge a governmental measure, therefore, obviously, a broad range of measures come under the purview of challenge and are a potential challenge before an investment treaty arbitration proceedings. Now, let us see what are those potential actions or potential measures which a state might take and might be in relation to COVID, either responding to COVID or to situations arising out of COVID. And how would these actions be perceived if such investment claims are initiated? Now, there would be two kinds of measures which might be involved in relation to response to COVID-19. First, measures taken directly to address the crisis itself. And most of these measures will be in the nature of protecting of public health. And even lockdown is, in a sense, a kind of a measure which is in response to the pandemic itself. But the issue doesn't end there, because in addition to the pandemic itself, there would be several measures which states have already undertaken and may have to undertake in years and times to come to address several other problems which may arise because of the pandemic, mostly economic and also involving public health. What we do see that already some of these measures have come under the scanner of investment treaty arbitration, if one can say that. So at the moment, there are three examples which, in a sense, indirectly, if not directly challenging a governmental measure in response to a pandemic, but indirectly, or in a sense, measures having an indirect effect on the investors have been challenged. The three examples, all three of them come from Latin America. First is the example of Chile, where the Chile allowed the pensioners to withdraw amounts from their pension funds, which are privately held. And this measure is undertaken in order to ease the financial effect on the families and individuals so that they can withdraw from their pension fund in light of the current pandemic. In response to that, certain US-based funds who have stakes in these funds have threatened to initiate investment arbitration against Chile. Now, as I told you, this is probably the second category where the measures of the government are not directly addressing the pandemic, but trying to address the consequences of the pandemic. The second example is of Mexico, where Mexico has reduced or intends to reduce the amount of energy generated from renewable energy sector. Now, this reduction of targets is going to have a consequence on foreign investors. And those investors who are suffering or would not be able to produce that much electricity, or would be producing the electricity, but the government is not going to buy that electricity which it had originally promised, they are also going to are contemplating initiation of arbitration proceedings. Now, the reason why the government has changed its policy of renewable energy sector is because of shortfall in demand due to the pandemic, because offices are not working, so energy demand has gone down. So therefore, the government had to reduce its target. Just to keep in mind, last year, an ICSID tribunal gave an award in ESPF versus Italy, where there was a similar situation without the pandemic. That is where the government revised its target of renewable energy. And then as a consequence, Italy was ultimately found responsible and had to pay compensation for reducing the targets and the losses that the foreign investors suffered. The third example is from Peru. In Peru, the government decided to remove toll tax because people are in dire financial situations. People may not be able to pay the toll tax, so the government decided to remove certain toll tax. A Colombian investor threatened to initiate arbitration proceedings. Apparently, the Constitutional Court of Peru itself has struck down that law, but we don't know what the government is going to do thereafter. But there's, of course, the possibility of initiation of arbitration proceedings there as well. What we are talking about are realistic situations and realistic challenges. Now, let us see what does the law has to say on all these issues. The chair of this session very rightly highlighted different treatment standards based on which the actions of a host state would be challenged and investigated. I need not get into details of those because every treatment standard would be fact specific and would depend on specific circumstances of a given case. But we can certainly conceive of fair and equitable treatment, indirect expropriation, probably not so much discrimination or even discrimination at some stage, because in the case of Mexico, some investors are claiming that it's actually a discriminatory provision. So there would be a host of treatment standards which might be raised, and it would be too speculative for me at this stage to assume which of those might be raised. And whether they are satisfied would also depend on the facts. But what I want to focus a bit more is what are the potential defenses that states can raise in this situation. Obviously, the first set of defenses would normally come in from BITs. But as most of you would probably know, BITs normally do not provide for a lot of defenses in themselves. Of course, the famous necessity defense, which has been a part of certain Argentinian bilateral investment treaties, I'm going to come to that a little later. But apart from these treatment standards, or rather defenses, which exist in BITs, there is a much larger area of customary international law. And customary international law allows states to invoke far more defenses, even if they are not contained in the BIT. It is a fairly settled position of international law that a customary international law rule, unless it is excluded expressly or impliedly, would continue to operate, continue to have force, have effect. Therefore, there is no reason why an investment tribunal would decline to apply these customary international law standards, particularly because most of these defenses are extremely well settled in customary international law and even codified primarily in the Articles of State Responsibility drafted by the International Law Commission, rather prepared by the International Law Commission. Chapter 5 of the Articles on State Responsibility provides for what is called circumstances precluding wrongfulness. In other words, which means you can do a wrong. You might have committed a breach of an international obligation, or you might have violated your obligations under a BIT. Even after having violated them, you are still precluded from responsibility for having done that. So it is a valid defense. You can very well rely on that defense. There are 4 defenses which emanate from Articles on State Responsibility. First, force majeure. Second, distress. Third, necessity. And fourth, compliance with Hughes-Cogan's norm. I'll touch upon them briefly. Now, force majeure, as contained in Article 23 of the Articles on State Responsibility, allows whenever a state to take a measure to breach an international obligation, in other words, to violate its BIT obligations, if there is an occurrence of an irresistible force or unforeseen event. Many may want to say that COVID was certainly not a foreseen event. Although I was on a panel sometime back in an event organized by the British Institute, and there was one partner in a law firm from London who was saying, well, no, everybody was expecting the pandemic to take place. Well, I'm not sure if who were those who were expecting such a pandemic to take place and to have such an impact. But this matter is something which might come before some tribunal to decide at some stage. I would not want to express any views on that issue really. But apart from this being an unforeseen event, it has to be also beyond the control of the state. And it should make it materially impossible for states to perform their obligations. And the state should not be at fault by itself and should not have caused the problem. So force majeure, and I think you already had a panel on this, is very much settled principle of domestic law. But the elements of force majeure under domestic law need not necessarily match with the elements of force majeure in international law. But these elements, as contained in customary international law, would have to be satisfied. The second defense is of distress in Article 24. Now, this provision of distress really comes from distress at the sea and distress at the air. And UNCLOS and the ICAO Convention, the Chicago Convention, have extensive provisions on distress. Now, these provisions are really aimed to protect human life. And if one looks at the Rainbow Warrior case, where the tribunal said that life has to be in immediate threat. And the person who's taking a measure, so the person has to take the measure to protect himself or herself and to protect the life of somebody else who is under his or her control. Now, distress, and particularly Article 24, has developed in a very peculiar situation. And that peculiar situation is of when somebody is in distress on the sea or in the air. Would this be applied to a general state of distress? Would it be applied to a general situation of a pandemic? We don't know, because if we look at the fair and equitable treatment, which was otherwise a very narrow standard, has been quite liberally interpreted by tribunals. It's quite possible that a tribunal may want to interpret it liberally, or some arbitrator may want to take a very narrow view and say it doesn't apply to general regulations which states may adopt. The third defense is of necessity, and we do see some jurisprudence on that. And this primarily arose in the context of Argentinian cases, where the government took measures in order to protect the economy. Most of the tribunals did not find in favor of Argentina except one. But eventually, when all these went to the annulment proceedings, and the proceedings were presided by Professor James Crawford, now Judge James Crawford, who found, because he was the special rapporteur on these on principles, found that the necessity done by these tribunals is incorrect. I can hear a lot of noise. Okay, it's receded now. So Article 25, which provides for necessities, again has been considered to be a very high threshold to meet. You can't invoke necessity unless that's the only way that a state can undertake against a grave and imminent peril. And this requires the only way to respond to the one where the tribunals may tend to have certain amount of discretion to decide whether this was the only way that states could have adopted. And whether this was the only way would certainly depend on specific facts and circumstances of the case at hand. Although in the past, the necessity defense has always failed, in particular in Gapchekovo, Nagyamaros, the ICJ took a very narrow view while the commission was still working on necessity, but ultimately the commission had to come around the same fact and take a very narrow view of necessity. But despite its narrow view, there's a possibility that these defenses could very well be raised. And an interesting case in hand to keep in mind is the Russian indemnity case. This was a case where the Ottoman Empire was supposed to pay back its debt to the Russian Empire, but it could not because of its dire financial situations. And very similar defenses of the kind that we hear in this context were also raised there. So there are some situations, there are some of these circumstances where these defenses could be raised. The last defense, the fourth one, which emanates from Articles on State Responsibility, is compliance with Jus Cogens norms. A state can very well breach its international obligations and defend them by saying that we took these actions to protect or to, in a sense, uphold and comply with our obligations to comply with peremptory norms of general international law, that is Jus Cogens. Now, it would be a crafty area for the state in a given case to show how their actions would fall broadly into one of the peremptory norms of general international law. Of course, it is not an easy task, but in light of the fact that we have issues of public health, there might be some arguments which could probably be put forward. Now, this is not the end of it, because even outside the Articles on State Responsibility, there is a defense in the law of treaties as well. Some scholars keep disputing whether it is a defense or not. In my view, it is certainly a defense, and a state would not be precluded from raising it. But raising of that defense is very much contextualized because it arises from the Vienna Convention on Law of Treaties and in the context of treaties. And that is Article 62, which codifies what is known as the traditional rule of rebus sic stantibus, that is fundamental change of circumstances. According to Article 62, if there is a fundamental change of circumstances from the time at which states enter into a treaty, and there is a radical transformation of the extent of the obligation due to the underlying circumstances, then states either have the obligation of terminating a treaty or suspending its treaty obligations. So there is a possibility of suspending temporarily. But a state would have to take certain measures in regard to suspension of these obligations in order not to be bound by any of these obligations. I see that the Columbia Center for Sustainability has put up a paper calling upon states to put a moratorium on investment claims, but I don't think any state has reacted as of now. It's really up to the states to decide if they want these obligations to continue or want these obligations to be suspended. But apart from these defenses which come under customary international law, the other prominent defense under customary international law, which is outside of state responsibility and Vienna Convention of Law of Treaties, which always remains, is the freedom of police powers, or what is called the regulatory freedom of states. The concept of police powers basically comes from American jurisprudence, but it's pretty much well recognized in international law even before its recognition in the American constitutional law. But in order to have a regulatory freedom, or in order to exercise police powers, the measure has to be bona fide, non-discriminatory, and public interest. Of course, public interest would be very much satisfied if a genuine public interest is shown. There would be issues of bona fide, which a state would have to prove on facts, and there would be issues of non-discrimination, which a state again would have to prove on facts. So if it's a general regulatory measure, a state could very well defend its action. The benefit of defending there is the defenses are much broader as compared to other specific defenses, which are much narrower. And the history shows that on most occasions, most of these defenses have failed to produce results for the states. Before I conclude, I think the last point which I wish to highlight is about the precedent in the field. And we do find one curious case buried quite underneath there, which is the Bischoff case. Now, this Bischoff case was a case which was decided by a Germany Venezuela mixed claim commission. And this mixed claim commission was looking into the fact where two police officers have taken over the carriage of an individual, and this individual whose carriage was taken over was complaining that my carriage was wrongfully taken over. So in a sense, it was expropriated. It was a delictile taking over of his private property. Now, what the government was saying and what the police officers said, that they apprehended the carriage or took over the carriage because they had information that there was a smallpox spread and there was a possibility of smallpox virus being in the carriage, and therefore they took over that carriage. Eventually they found that there was no smallpox. And then ultimately the issue was whether the state is responsible for taking over the carriage to pay compensation in a situation of a severe health emergency. Of course, it wasn't an emergency of a general nature, but of a very specific kind. But nevertheless, the decision is instructive. Although we need to understand these mixed claims commissions work more on a diplomatic way, because the representatives of each state would try to present their own side's case even on the tribunal, and it was the umpire whose decision mattered. The decision is not very clear, but the umpire did conclude that if a government is exercising its discretion for protection of public health in situations like this, it would not amount to breach of an international obligation. However, there was a certain amount of compensation which was given because the factual support of the measure was unfounded. Now, this is where the situation of the law is. We don't know how these legal principles would be applied, because there are several factors which go on in an investment treaty arbitration. As Winston Churchill famously said, you can only begin a war, but you can't control it thereafter. Investment treaty arbitration proceedings, like international litigation, are pretty much like that. You don't know which issue will get highlighted and which issue will be pulled in which direction. But these legal issues, in my view, which have been underexplored in international law, are certainly the ones which might come up as we face this issue of pandemic and the possibility of these challenges. With that, I'll end, and thank you very much. Sorry for the troubles on the technical side on my part, but I think the sign of a good lawyer is to be technically handicapped. I think I've at least managed to get that one. So thank you very much to the organizers, and thank you very much to listening to me. Thank you.
Very good, Dr. Rajput. Thank you very much for that very illuminating discussion. I think that the whole issue, of course, of claims, the sort of change of that leverage that investors may have, and the development of what may be sound defenses based on international law, customary international law, is one of the big developments that we'll see out of COVID. Let me go to the next speaker, who will be talking about corruption in transparency in international investment arbitration. And that is Dr. Kasibatla, who is the Deputy Legal Advisor of the Department of Legal Affairs at the Ministry of Law and Justice of India. And he's currently serving in that capacity. Before that, he had been an advocate before the district courts in and around Kakinda, and attorney for patents and trademarks. He's also been an assistant professor at the WB National Law University for Juridical Sciences. As a legal advisor, he's involved in active involvement in bilateral investment promotion and protection agreements, negotiations with numerous countries on behalf of India. At least among the countries identified have been Saudi Arabia, Canada, Greece, and the United States. I know that both in international investment arbitration, as well as in sort of classic commercial arbitration, the whole issue of corruption is one that is being confronted, ever more often by arbitrators, and they are developing their approaches and solutions. And with that, let me turn it over to Dr. Kasibatla.
Thank you, Professor Don. Good morning to you, and good afternoon to other distinguished friends, ladies and gentlemen. It's a great honor and a pleasure and privilege on my part for being associated with this international symposium. For that, I'm grateful to Professor Garg for affording me this opportunity, and I feel it's a great honor. To begin with, corruption is a most dreadful disease which shackles the economy of a nation. So that is why the importance of corruption in international arbitration. When the Supreme Court of India annulled more than 120 contracts relating to allocation of 2G spectrum in telecom sector, several petitions were filed both under the commercial arbitration and as well as under the treaty arbitration, questioning the action taken by the government of India pursuant to the decision of the Supreme Court. It happened so because there were severe allegations regarding allocation of spectrum to these telecom service providers on the basis of some reports and on the basis of some documentary evidence that these licenses were obtained on the basis of fraud and corrupt practices. Therefore, they filed several cases by invoking the provisions of bilateral investment treaties that India signed with different jurisdictions. Hence, the importance of the subject with reference to the arbitration cases invoked both under the investment treaties as well as under the commercial agreements. Corruption allegations have blossomed as an area of interest since 2006. But there is no established approach currently exists for the standard of proof that applies to corruption cases. Institutional rules of arbitration do not contain a clear definition of corruption nor guidelines on how the tribunals should examine the evidence in corruption. Because unless the corruption allegation is proved, it is very difficult for the tribunal to come to a conclusion whether the investment agreement is influenced by corrupt practices or not. But unfortunately, there is no standard rule or standard procedure established so far in institutional arbitration or under the rules how the tribunal should examine the evidence relating to the corruption in case of investment treaties. And it is a settled law that claim under a contract through a bribery is not sustainable. It was held by the Exit Tribunal in World Duty Free versus Kenya, wherein the tribunal found that a claimant's conduct in procuring an investment contract through bribery was sufficient as a matter of law and international public policy to render claim under that contract unsustainable. And in India too, in some of the cases, took the plea of the corruption and the maintainability of the claim made by some of the investors, where the allegation of on behalf of India is that the investment agreement or the investment that was made by them is through corrupt practices. And it is also a well-settled law that the judgment should not be recognized if the seat court's judgment is tainted by procedural unfairness or corruption, or if it violates the enforcing court's public policy or is generally contrary to the fundamental notions of justice. The reason being, if a contract obtained on the basis of corrupt practices or corrupt means is allowed and justified, it shakens the public policy of a nation, because it goes against the very fundamental rule of law of the particular nation. The Convention on the Settlement of Investment Disputes between the states and the nationals of the other states, 2006, popularly known as the Exit Convention, allows a party for the interpretation, revision, and the annulment of the award by an application in writing addressed to the Secretary General. The various grounds on which the award is held liable to be set aside include the tribunal not being properly constituted or it has exceeded its jurisdiction, corruption on the part of any member of the tribunal, departure from the fundamental procedural rules. The exit rules permits for annulment of an award if it is on the basis of a corruption on the part of an arbitrator. But at the same time, I would like to emphasize that allegation of the corruption is a serious issue. Investment arbitration tribunals view allegations of corruption as a serious matter requiring a very high standard of proof akin to that of which would be applied to criminal proceedings. In a number of cases, the tribunal analyzed the allegations relating to the corruption and they felt that they require a very high standard of proof akin to that of a criminal proceedings in relation to a criminal case. So therefore, the question here is whether it would be proper and prompt to equate a civil proceedings where a corruption allegation is leveled on par with the criminal proceedings and raising the bar of the standard of proof on par with the criminal proceedings. In Vale versus BSC Resources Limited show that while corruption is always a serious accusation, the standard of proof applicable in arbitration should be no higher than the standard required in other civil cases. If that is the case, then raising the standard of corruption evidence on par with the criminal cases may go contrary to this observation of the tribunal in Vale versus BSC Resources, where the tribunal observed that raising it to beyond the civil case may not be proper and prompt. At the same time, the tribunals very often insist for clear and convincing evidence in the matters where corruption is alleged. For example, if we make an analysis, for example, like the cases like World Duty Free versus Kenya, Fraport versus Republic of Philippines, like that, out of 24 cases, in 14 cases, the tribunals insisted for clear and convincing evidence. But at the same time, there is a problem with the clear and convincing evidence standard. There are challenges because if there is an allegation of corruption by a state, the standard is different. If there is an allegation of corruption by a private individual, the standards are different. That's what. Where a state raises a corruption allegation, or heightened standard of proof may be more readily justified. States enjoy the power to undertake investigation and compel the production of evidence of the alleged corruption prior to the arbitral proceedings. Where corruption allegations are raised by private parties against the state, however, the challenges surrounding these higher standards are revealed. For example, in EDF versus Romania, where a corruption was observed as notoriously difficult to prove. It is a case where the corruption allegations were leveled against the highest officials of the government of Romania. In this particular case, the case relates to a demand of bribe to an extent of 2.5 million US dollars. The claimants alleged that the officials of the Romanian government demanded 2.5 million US dollars for doing the renewal of the contract or doing the favor for that contract. In this particular case, the tribunal, though acknowledged that the corruption is notoriously difficult to prove. Why? Because there won't be any physical evidence cases of corruption like the other criminal cases. In other criminal cases, there may be corroboration, there may be hearsay evidence, there may be some substantive material relating to the happening or event of a crime. But in case of corruption, it's very difficult to procure or get the physical evidence. That is why, in this case, though it was acknowledged that the corruption is notoriously difficult to prove, since typically there is a little or no physical evidence, the tribunal insisted on the clear and convincing evidence standard because the case is an allegation against one of the highest officials of the government of Romania. In such a case, how do we justify adhering to the principle of clear and clinching evidence in case of allegations relating to corruptions? At the same time, it is ought to share, it's customary to bring into light that the tribunals have developed their own approach in deciding matters relating to corruption in investment treaty arbitration cases or commercial arbitration cases. In view of the uncertainty in investment and commercial, tribunals have developed their own approaches to the standards required to prove corruption allegations. But the standard of proof itself need not be very higher, as observed by the tribunal again in Nico Resources versus Bapex Petrobagra, where the tribunal observed that because corruption is a serious charge with serious consequences attached, the degree of confidence a tribunal should have in evidence of that corruption must be high. However, this does not mean that the standard of proof itself should necessarily be higher. Therefore, there is no yardstick to measure what should be the standard of proof for corruption. There is no appropriate yardstick to measure. In one case, the tribunals follow one method. In another case, the tribunals follow another method. In some cases, they say there must be clear clinching evidence. But
I think you don't mute Dr. Kasi Batla. Can you just check once? Sir, I think you don't mute. Is it same for everybody else?
Now, am I audible?
Yes, sir. Now you're audible.
Yeah, okay. In Senna's case, reference to an agreement to which CPL Industries commenced arbitration proceedings for payment of certain outstanding sums of money for services provided, wherein the sinners argued that in order to obtain the public tender contracts, CPL Industries had bribed Nigerian officials and therefore the contracts were in violation of the Nigerian public policy. However, the sole arbitrator found that the evidence was insufficient to establish corruption by the officials of CPL Industries and accordingly ordered the signers to pay these sums due to CPL Industry. On appeal, the Paris Court of Appeal rejected the arguments of corruption. And at the same, in another interesting case, the Paris Court of Appeal annulled an award under the Untitled rules. It was decided by the Court of Appeal in Valerie Balokan versus Kyrgyz Republic. It's a case where the dispute between the parties arose under the Latvia-Kyrgyzstan bid in 2010 during a period of political tension in Kyrgyz Republic. It's a question of operation of 5 banks in the Kyrgyzstan, and thereby the claimants made claimed that the state appropriated their money, they appropriated their bank. That's what the contention on behalf of the claimants. Per contra, it was the contention of the state that the money what they floated through these banks and financial institutions is by means of corrupt and by means of money laundering. So they say that it's the proceeds of crime. Therefore, the claim made by the claimants is not maintainable. However, the award was given in their favor for payment of that amount. But on Court of Appeal, it was established that not only in this case, in another similar case also, the plea of money laundering and the corrupt practices was upheld. Therefore, the Court of Appeal annulled the Untitled award on the grounds that the money what they floated in these banks or financial institutions as an investment is not a fair money and it is a corrupt money and it is a proceeds of crime. One issue I would like to flag regarding the variance in deciding the cases relating to corruption under the investment treaty arbitrations is the tribunals do not have powers like a court. Like a court, they cannot summon anyone whom they feel necessary or appropriate for examination of the corrupt allegations. It is quite possible for a court to do so. It is quite possible for a police to investigate and seize the documents what they feel relevant for a particular case. But the tribunal is lacking these powers and they cannot summon anyone whom they feel appropriate for the consideration of a case. And that's the reason why they strictly go by the facts that are produced before them and the witnesses what they had before them, and on the basis of those reliable information the tribunals are deciding. This might be the reason for having their different approaches in deciding different cases. But in Metaltech versus Uzbekistan, the tribunal come up with a pragmatic approach because they realized that there is a problem in clear clinching evidence method and there is a problem in raising the standard of proof in case of corruption evidences. Therefore, in this particular case, the tribunal itself conducted an inquiry. It is relating to some manufacturing issue, production of issue in Uzbekistan by the Metaltech, wherein the tribunal used the red flag analysis and reached the conclusion on the basis of the red flag analysis of indicators of corruption. And this is a pragmatic approach. But at the same time, the question that may arise here is, would it be proper on the part of the tribunals to go for pragmatic approach in each and every case? That is again a debatable issue, because one man's food is another man's poison. In this one particular facts and circumstances, the pragmatic approach may be a wise decision. But in another set of facts and circumstances, going for a pragmatic approach may not be a wise decision. And coming to the Indian version of the bilateral investment treaties or promotional protection agreements, the pre-revised text what India negotiated since 1994 and entered into more than 84 bilateral investment agreements, there is no specific provision relating to corruption in the investment treaties. But the revised draft model text, what is evolved in 2016, contains a specific provision relating to this corruption and corrupt practices. The Article 11.2 of the model revised text of bilateral investment treaty categorically refers to the corruption and corrupt practices. And it also says that an investor may not submit a claim to an arbitration if the investment has been made through fraudulent misrepresentation, concealment, corruption, money laundering, or conduct amounting to an abuse of process or similar illegal mechanisms. Because it is a well-settled principle across the globe that he who seeks equity must be at equity. When you need an equity, you must come to the tribunal with clean hands. If the hands of the claimant are not clean and they are dirty, then the claimants have no right, have no locus standi to stand before the tribunal for a remedy or for a compensation. That is the importance of corruption and arbitration matters. At the same time, the Indian Arbitration and Conciliation Act, which is on the model text of the Uncitrol model draft, is having a provision to address the issues relating to arbitration awards obtained by means of fraud and corrupt practices. And no doubt there are no uniform standard procedures for assessing the evidence that is produced before the tribunals in the matters relating to corruption allegation. Even India, in some of the important arbitration cases like Antrix Devas, the claim of corruption has been made, but again, the matter is still pending under consideration. Therefore, may not be proper and prudent on my part to share much details about that. But the fact remains here is, if an action is taken on the basis of allegations of corruption, on the basis of prima facie establishment of corrupt practices, would it be proper on the part of the tribunals for not considering or annulling that kind of evidence or that kind of prima facie proof, and thereby declining to accept the averments of corruption is an important issue to be raised or to be considered. Since the Uncitrol Working Group 3 is examining the issues relating to investment settlement disputes, they may be proper and prudent on their part to raise the issues of corruption in case of investment settlement disputes. Law being a living organ cannot remain static. As and when new situations arises, the new law has to be evolved. And transparency plays an important role in checking up the corruption issues. With these words, I conclude, and once again, thank you for affording me this opportunity. Really, it's a wonderful opportunity to associate with eminent personalities like Don and Anirudh Rajput, and of course, my dear friend Pramod. Thanking you all.
Sir, you're on mute. Mr. Don, you're on mute.
Can you hear me now? Yes, excellent. Okay. Thank you, Dr. Kasibatla, for that very sort of deep dive into the issues, not the solutions necessarily, but the issues of corruption and how they confront these arbitral, how they're involved in claims that are asserted by investors in these bilateral investment treaties. I want to turn to our last speaker. I apologize for maybe truncating his time, perhaps a bit. So, Pramod Nair, please forgive me. He is going to be speaking on the Multilateral Investment Court. Pramod is an advocate in India, dispute resolution expert, a partner at Arista Chambers. He had prior experience as a partner at JSA, solicitor advocate for Herbert Smith in London. He has been counsel to the Republic of India in arbitrations involving bilateral investment treaties. He's represented India at the United Nations. He also is as counsel to parties, commercial parties, in lots of arbitrations as well that have been conducted in many jurisdictions, including Europe and Asia, and under a lot of institutional rules. The London Court of International Arbitration, the Singapore International Arbitration Center, etc. So very deep experience as an arbitrator. And with that, I'm going to turn it over to Pramod to talk about this. In some ways, it's a new concept, I guess, or maybe it's been around for a while, but a new concept to get rid of arbitration and let's go to an international investment court somehow selected. Or maybe it's arbitration, but they're going to call it a court. Anyway, I'll kick it over to you. Thank you, Pramod.
John, for that very generous introduction. Thank you, Dr. Garg, for the generous invitation, and to your band of enthusiastic students who put together this stellar event. It's also a privilege to be on a panel with Dr. Kasi Butler, with whom I've worked very closely in defending India in a number of BIT arbitrations, and Anirudh Rajput, who's a good friend. So thank you very much for having me at this event. I think time is short, so let me dive right in to the topic. The topic that I propose to address today is the Multilateral Investment Court. And what I will try and do is in the first part, deal with the key drivers for the demand for establishment of a Multilateral Investment Court, and then look at the various proposals that are being made in relation to the constitution and architecture of the Multilateral Investment Court, and probably also discuss very briefly some of the other alternatives, what are called as incremental changes to reforming the system of investor-state dispute settlement, or ISDS. On the issue as to why a multilateral investment court is considered to be necessary, there are many who point to the rather fragmented nature of the system of investor-state dispute settlement. There is an issue with the lack of coherence and consistency in the manner in which different tribunals approach broadly comparable or similar issues of law. There is no system of precedent in international investment arbitration. That's a problem. There are a number of process issues which have antagonized, especially states who believe that they are at the receiving end of some of these abuse of process issues. There is a legitimacy crisis in relation to how the present architecture of ISDS has been created. And also in recent times, there's been a lot more focus on the fact that there probably exists a diversity deficit, especially in the constitution of arbitral tribunals, to decide claims against states. So these are broadly some of the major drivers for the demands for creation of a multilateral investment court. So let me deal with them one by one very briefly. The first aspect is could probably be lumped together and described as process issues. And the main concern here relates to allegations of abuse of process by investors, mainly through the initiation of multiple or parallel proceedings in respect of what is essentially the same cause of action. There have been multiple instances of multiple proceedings being initiated on the same cause of action or on the basis of the same facts, because probably there are multiple sources of the claim. Investors bring claims under the relevant contract. Then there could be a parallel claim under the investment treaty. They could also be claims before the national courts. And you could also have a system where multiple claims can be brought under more than one treaty by different actors involved in a dispute. For example, different shareholders could bring claims, under different bilateral investment treaties dependent on the nationality of the shareholders. I think India has been at the receiving end of one such, of probably more than one such claim. And I think a case in point is the Antrix-Devas dispute, and the facts of which are in the public domain. The Antrix had cancelled a contract with Devas, and this led to a contractual ICC arbitration by the contractual counterparty. But the shareholders of Devas also commenced claims against India under the India-Germany BIT as well as the India-Mauritius BIT. So you can see how the same set of facts and the same dispute essentially has resulted in multiple claims. I think very early on, there's also the case of CME, Czech Republic. CME versus the Czech Republic, and Ronald Lauder versus the Czech Republic, which is again cited quite frequently as an abuse of process. Now, why is this a problem? This is a problem because, first of all, whenever there are multiple proceedings, there could be conflicting decisions, and that's a problem. There could be inconsistent outcomes if there are parallel proceedings. The second, there could be instances of double or multiple recoveries being made by investors, which could be complicated to reconcile and adjust across multiple awards, especially when these awards are required to be kept confidential, which is a requirement very often. It is also a problem because multiple proceedings waste resources of both the state and the investors. Developing states and less developed states find this problem to be more acute because with scarce resources, their legal teams and their resources are often stretched in having to defend multiple claims by investors on essentially the same cause of action. So that's the gamut of issues relating to abuse of process. As far as inconsistent or incoherent decision-making is concerned, there are concerns expressed in various quarters about the consistency and the correctness of decisions made by arbitral tribunals in ISDS cases. Like I mentioned, there is no system of precedent in the international investment law framework. And of course, the BIT framework itself is not uniform. There are many different BITs, probably more than 3,000, and it would, of course, be impossible to achieve a uniform interpretation of provisions without recognizing important differences in the language of different treaties. But as far as the criticism relating to consistency is concerned, the problem has arisen because different tribunals have reached different conclusions about the same standard in the same investment treaty. For example, in the context of Argentina's financial crisis, the state took a number of measures to deal with the economic emergency it was faced with, and these were sought to be justified on the grounds that they were necessary for the protection of Argentina's essential security interests. While the same measures were considered to be a legitimate necessity defense by some tribunals, other tribunals were rather emphatic in their rejection of the necessity defense to broadly the same set of facts. And there are many examples of this. I don't want to, I probably will not be able to go into those for lack of time. The third aspect is the concern of legitimacy. We had a seminar recently where a very eminent arbitrator in the ISDS system, Dr. Gabrielle Kaufman-Kohler, made a very important point. And she identified that one of the major concerns of legitimacy or relating to legitimacy in the ISDS regime is the fact that democracies trust institutions, and an arbitral tribunal is not really an institution. So on one side, while democracy trusts institutions, there's also a corresponding distrust of powerful individuals who are not selected through a transparent process. And this is a factor which has negatively impacted perceptions as to the legitimacy of ISDS. The fourth major concern, which I alluded to, was the lack of diversity in the composition of arbitral tribunals which are called upon to deal with investment cases. If you look at the pool of arbitrators appointed in ISDS cases, only about 20% of the appointments are from the non-Western world, whilst ISDS involving non-Western countries constitute a much larger percentage of disputes. A small pool of very busy arbitrators are often also counsel for parties in other ISDS disputes, the problem of double hatting. And then there's also the concern that repeated appointments by the same parties and law firm raises questions about the independence and impartiality of arbitrators who are appointed. So therefore, these are the broad concerns that have fueled the demand for structural reform and probably incremental reform of the system, and also resulted in demands for the creation of a multilateral investment court. Before I go on to the multilateral investment court itself, there are some who advocate less far-reaching reforms. They're broadly referred to as incremental changes, and the incremental changes are those that relate to the adoption of, for example, a joint code of conduct for arbitrators to prevent the problem of double hatting to a large extent, the setting up of a multi-level advisory center which could provide assistance to states which do not have the capacity to defend themselves in BIT disputes, and then processes for screening arbitrators and increasing transparency in the system. Now, as far as these structural changes are concerned, the main focus of those who advocate the structural reforms to the ISDS system is to do away with the current ISDS regime and replace it with a permanent multilateral investment court, which would decide investment disputes across treaties. Establishing such a permanent court would address to a large extent some of the major concerns in the current ISDS regime by providing for legitimacy to decision makers, greater consistency across decisions, and the ability to deal more effectively with multiple proceedings or parallel proceedings. That doesn't mean that this is a proposal that is not without its own challenges. There are a number of challenges to establishing such a world court for investment. Important questions that would require consensus among states would be who should sit on the court and who should decide who would sit on the court. And these are important questions to be answered whilst designing a multilateral investment court. If this system is to be reformed and a multilateral investment court is to be brought in, I think it is critical that ensuring impartial and depoliticized appointments of judges is something which is entrenched in the architecture of such a court. There could be, for example, rules regarding geographic diversity to address the diversity challenge. There could be a requirement for having more judges from the developing regions, more female judges to be appointed, etc. There could also be, for example, a roster which determines at random which judges are to hear a certain dispute, so that concerns regarding loading a particular panel or a tribunal in favor of a state or an investor can best be avoided by having such a random framework. In terms of also of ensuring the efficacy of the system, I think it's important to ensure that if a multilateral investment court is to be established, it is fitted in almost seamlessly within the existing architecture that we have for enforcement of arbitral awards. And that again has its challenges. I think that's a very complex topic, which for the paucity of time, I wouldn't want to go through. So I think these are some of the challenges that the Ancestral Working Group 3, which both Dawn as well as Dr. Kasi Butler referred to. There are many proposals that are being considered by the Ancestral Working Group 3. There is a proposal, for instance, to have a multilateral investment court with a two-tier structure. The first tier of review would be an arbitral tribunal, and if either party is aggrieved by the decision of the tribunal, then the matter can go before an appellate committee or an appellate forum. There are other proposals as well to have, for example, instead of a multilateral investment court, to retain the existing system of ISDS tribunals, but with a harmonized global appellate mechanism only, which would then sit and appeal over decisions of tribunals that are constituted under each of these BIT. So all these are proposals that are being actively discussed by UNCITRAL Working Group 3. I think for paucity of time and before Dawn starts to prod me, I think I should bring my presentation to a close. But if there are any questions at the end, I'd be very happy to take them.
Thank you, Pramod, for that. I know that we are at the sort of after our allocated time, so I don't think that we're going to have opportunities for questions. Bear with me. Can you hold on one sec? Okay, hopefully this will be better. I've been trying to use two different machines because they're each having their own sets of problems. But let me say that I think this has been a real tour de force for those of you who are, sort of beginning to think about these issues. I must say that what you've gotten is a very, in some ways, deep survey type presentation on state responses to the COVID claims. So it's a very timely set of issues that we're dealing with right now. And for that, I want to thank very much Dr. Rajput. On the corruption matters and how you deal with what are really quite complicated and important issues. And actually corruption, there are many people that would say corruption is really different than money laundering. Is it appropriate to lump the two together? And so there are actually different aspects that need to be teased out. But if you are a panel, or actually if you're any fact finder trying to reach a decision and a claim of corruption is alleged, that takes you into a totally different area. How should the fact finders, the sort of the arbitrators, the judges deal with those sets of issues? Very, very complicated. And for that, I want to thank Dr. Kasibatla for that very sort of thorough presentation. With Mr. Nair on Multilateral Investment Court, I think that he gave us a very, very good summary of the sets of issues that are involved and the reason that there is so much interest in some sort of mechanism, and whether it's an appellate mechanism, whether it is a full multilateral investment court, and sort of the sets of issues that are giving rise to that. My hunch is that while it will still take some time, that there are enough states, remember on this, many states are aligned, developing and developed, which is we don't want private parties and private arbitrators to be able to make major decisions that impact sort of the public and the public welfare. And we need to find the right sort of mechanism to deal with that. I think with that, Professor Garg, can I turn this over to you? I think we're at the conclusion of the first day, and you may have some remarks that you wish to make. Okay, I think we may have lost Professor Garg. Anything else from any of the panelists? Okay, and with that, I wish you all a good good rest of your evening. For me, I start the day. It is 7:15 here. I'm actually down in the southern part of the United States, and hope to. I could tell from the agenda that this was a very rich entire symposium. I know that the sort of issues of dealing with a virtual symposium can be challenging, and I hope we've done this in a way that you've all been able to mostly hear us and that we've proceeded forward. So with that, let me say goodbye, and I will sort of terminate this. Thank you to all of the speakers on the program. Thank you very much.
Thank you, sir. Thank you very much.
Thank you.